Good morning, everyone, and welcome to our final session of the Gardner-Roberts Toolbox Seminar Series in 2016. And this time we thought we would do something a little different. Usually we have individual presentations, one after another in a series. And we thought this time, maybe because of the recent U.S. election, any number of international developments, that there are so many issues on cross-border that we as practitioners face every day. A panel discussion dealing with a myriad of problems might be an interesting way of at least identifying issues, coming up with some solutions, and then engendering some further discussion. But as usual, we would like to start with a hot topic. And there were a number of changes in the last federal budget. Because our focus in our seminars and today is on families, businesses, entrepreneurs, and so on, we thought that the changes to the principal residence rules would be a good way to have a hot topic to start with. So I'm going to call shortly upon our first speaker, Josh Harnett, a tax associate in our group. And then we'll have our panel discussion where Lindsay Histrup, my co-chair for these seminars, will be focusing on the estate and tax side. Pamela Liang, who's just joined us this year as an associate in the estates group. And at the end, you don't see him yet, but he'll be here shortly, Jim Parks, counsel on the tax side, and I'll be talking about some of the cross-border tax issues. So let's begin. Josh?
Good morning. So as Lauren said, I'll be speaking about the recent changes to the principal residence rules. For those of you who are not aware, the Department of Finance did one of its usuals and surprised us with some unexpected legislative changes just back in the beginning of October, proposing a series of changes to the principal residence rules. This was part of the package of announcements that came out to make the housing system better by tightening up mortgage rules, and they decided to throw some of these changes at us as well. I'm going to go over three legislative changes, which are changed to the 1+ rule, which some of you may be familiar with, changes to the types of trusts that are eligible to claim the exemption, and then a minor change to a rule that we usually don't like, which is in subsection 107.4.1. And then lastly, there's been some changes to compliance regarding the exemption, how you claim it, whether you can claim it, that I think a lot of people need to be aware of and may not be. So starting with the 1+ rule, when you have a principal residence, individual taxpayers can only claim a single property, designate a single property as their principal residence for any particular taxation year. And so in the normal course, as I did this past year, people buy and sell houses sometime during the middle of a year, not, say on December 31st and January 1st. And so you're going to have a situation where you have two properties that are going to be your principal residence for the same taxation year. And if there was nothing in the Act that allowed it, you would have a gap where for that particular overlap year, only one of those properties would qualify for the exemption. So say you sold a property and claimed the full exemption for that property, the new property would have 1 year of its gain not available to be sheltered. In order to protect against that, Department of Finance realizes that's not appropriate. We have the 1+ rule, which basically has, the exemption is a weird formula, and it allows you to increase the number of years that a property qualifies for the exemption by 1, so that you don't have a shortfall for any years where you have one of these crossover situations. Now, the exemption is usually only available where a property is a taxpayer's principal residence and that taxpayer is resident in Canada. But because of the 1+ rule, non-residents can actually claim the exemption for a single year of ownership. And so, think of a situation where, say, a child of a non-resident comes to Canada to study for 4 years and acquires a property. They acquire the property here. The child lives in it for 4 years. They sell it when the child leaves Canada, and they're going to get 25% of their gains sheltered by the exemption because of this 1+ rule. And that isn't fair. I mean, this is a rule to sort of support home ownership by Canadians. In the U.S., they have, the write-off for mortgages. We have this rule. And so the Department of Finance says, that doesn't work. We're going to get rid of that. So they've changed the 1+ rule, and it's now only going to apply to a taxpayer where the taxpayer was resident in Canada in the year the property was acquired. So if you were not a resident of Canada when the property was acquired, you're not going to get the 1+ rule. It's going to be just years that it actually qualifies as your principal residence and that you are a resident of Canada. And the finance said when they let this out that this is intended to prevent non-residents from accessing the exemption at all. I don't think this is a controversial change. I think most people understand it, and there hasn't been a lot of uproar about it. But we want to talk about controversy. We can talk about the changes to the trust rules. So the principal residence exemption can be claimed by any individuals, and for income tax purposes, that means natural persons and trusts. Trusts have always been able to claim the exemption subject to a number of requirements that I'll touch on in a second. It's not like it's a new thing. It's not a planning technique that people somehow weaseled into the rules. Trusts and estates are individuals. They've always had able to claim the exemption. And basically the three requirements, I'm simplifying here a fair bit, but there has to be a so-called specified beneficiary of the trust, and that's a beneficiary of the trust that inhabits the property or has a spouse or minor child that inhabits the property. No corporations or partnerships can be beneficiaries of the trust, and no other property can be designated as a principal residence of the beneficiary or their spouse, basically of that family unit. So you can't use a trust to multiply access to the exemption to get a second exemption for the family unit. For some reason, this is no longer acceptable. And beginning in 2017, only 3 different types of trusts are going to be able to claim the exemption. The first are these life interest trusts that we're all probably fairly familiar with: alter ego trust, joint partner trust, spousal or common law partner trust, and a type of trust you may not have seen before called an exclusive benefit trust. I won't spend too much time talking about that, but it's basically just a trust where the only beneficiary is the settlor. Now we also have qualified disability trusts. These are a new type of testamentary trust that was introduced along with the graduated rate estate rules. And finally, trusts for the benefit of a minor child of 2 deceased parents. So obviously very limited circumstances where these trusts are going to be able to claim the exemption, and your typical discretionary inter vivos family trust no longer going to qualify. Additional requirements that are going to come into play: the specified beneficiary, the one that we talked about on a previous slide, must be resident in Canada for each year that the property is designated as the trust's principal residence. This ties into that change with the non-residents. They're really focused on only Canadian residents being able to access the exemption. And where the trust acquired the property after October 3rd of this year, so after the date that these rules were announced, the terms of the trust must actually provide the beneficiary with the right to use and enjoy the property as a residence. So it can't just be sort of a wide open trust. It has to be specifically contemplating the use of the real estate. Why did they introduce this? This is their explanation. These criteria will improve fairness and integrity by better aligning trust eligibility for the principal residence exemption with situations where the property is held directly by an individual. That is the entire explanation contained in the backgrounder that came from the Department of Finance. They don't explain why there was a lack of fairness and integrity, why these rules were not lining up properly in their mind. I mean, they did give a very clear explanation on the non-resident issue and why that was not appropriate. To me, this doesn't say anything, and this is another example of the government bringing out a sledgehammer where a scalpel would have done just fine. There is some transitional relief being provided to existing trusts. If the property is owned currently in a trust, you have a principal residence trust set up, then the trust will be able to claim the exemption up to the extent of the fair market value of the property on December 31st, 2016. And the way that this is going to work is if the trust disposes of the property after the 2016 year, then the gain that's realized on the disposition is going to be effectively split in 2. There's going to be a notional disposition up to December 31st of 2016, and that gain will still qualify for the exemption. And then the portion of the gain that accrues after the end of 2016 will just be a regular capital gain, no exemption available. The obvious issue that jumps out with this is that if you have these principal residence trusts and you're planning to keep them going, you're going to need a December 31, 2016 valuation. This is kind of like a V-Day thing all over again. And obviously, the further and further we get away from the current market, the harder it's going to be to get these valuations. So if you have clients that have these trusts set up and you want to keep them going, really beginning in the new year to start contacting real estate appraisers to get these appraisals done and into the file. Subsection 107.4.1, as I alluded to earlier, usually not a rule we like to see. It's a rule that prevents the usual tax-deferred rollout of property from a trust. If subsection 75.2 ever applied to the trust, without getting too technical here, 75.2 is an attribution rule that applies where a settlor or beneficiary, it transfers property to the trust effectively and can take it back. It's not a good thing. It's an attribution rule, and it prevents a rollout. I think the department realized when they were making these changes regarding trust that a lot of these principal residence trusts probably are 75-2 trusts because people didn't care about them. They don't generate income. They were only meant to hold the principal residence. And so they want to make sure that you're not entirely penalized. So they've relaxed the rules, or will relax the rules in subsection 107.4.1, so that it will not apply where the property that is being distributed from the trust is a residential property that the trust owned at the end of 2016 and that would otherwise have been the trust's principal residence if not for the new rules. So it's pretty specific. If there's other property in the trust, shares or any other sort of things like that, they're still going to be caught by 107.4.1. But if you stuck the principal residence in the trust and you want to be able to get it out so that you can sell it and possibly claim the exemption, 107.4.1 is not going to block that rollout. This is intended to apply in conjunction with the continuity rule in subsection 40 sub 7 that says where a beneficiary receives a distribution of a property from a trust that was principal residence, it will be deemed to be owned by the beneficiary for the whole time it was owned by the trust. And that just allows the beneficiary to claim the sale, the exemption on the entire gain if they subsequently sell the property. Of course, the property will still have to be the beneficiary's principal residence for all the years of ownership. The other thing to think about, it's not on the slides, but I just wanted to throw it in, is deciding whether to keep these things going or to wind them up soon. It's all well and good if the beneficiaries are alive and well and they take the property out of the trust and they live in it for another 15, 20 years and sell it, you're going to be fine. If you have a situation where you're in the interim, you're not deciding what to do yet, and the beneficiaries that are living in the property pass away, and then you want to roll the property out to the residual beneficiaries, there's going to be a disconnect there if those residual beneficiaries didn't live in the property. There's going to be a situation where, yes, you'll have the rollout, yes, you'll get the continuity and deemed ownership, but the property won't be the principal residence of those beneficiaries. And so you're going to basically, in that situation, you're going to have to pay tax somewhere, whether you pay it in the trust or the beneficiaries are going to pay a whole whack of tax. But if there's situations where maybe these beneficiaries are ill or getting towards the end of life, planning is going to be undertaken very quickly to address these new rules. And then turning to the compliance changes. So the Income Tax Act has actually always required the reporting of capital gains from the sale of a principal residence, the designation of a property as a principal residence, and the claiming of the exemption. But the CRA has always administered the rule to say, look, if you've got this property, it's your principal residence, the entire gain is going to be exempt. You don't have to tell us anything, unless you're a trust. If you're a regular person, don't tell us anything, don't report the gain, just go on about your day. Reasons that aren't really explained, that policy is over. Beginning in 2016, so this change is retroactive to the beginning of the current calendar year, all individuals must report the gain from a sale of a principal residence, claim the exemption, and they're going to have to provide certain information with their tax returns related to the disposition, the address of the property, when it was acquired, proceeds, all those sorts of things. If the gain is not reported properly in the return and CRA reassesses the return, the exemption is going to be denied. You won't be able to apply for relief. You won't be able to say, oops, my bad, but really the exemption is there anyways. If you didn't report the gain, you're not going to get the exemption. You will be able to file amended returns if you forgot to report the gain, if you can get in before they do. The typical late filing penalties are going to apply up to a maximum of $8,000. This is considered like a late filed election. So the penalty is not insignificant, but in the context of a several $100,000 capital gain, it's probably worthwhile. Very important to note again that this applies to all dispositions beginning January 1 of this year. So as we enter tax return season in the new year, any clients that have sold their principal residences this year, the reporting is going to have to be done. No reporting, no exemption. If there are no questions, thank you.
So thank you, Josh. I just wanted to add something to this because I have used principal residence trusts for completely non-tax reasons for years, in particular to protect situations where parents are buying houses for married children or for children who are just wayward, but have no disabilities. And this change is quite dramatic, quite unnecessary. And the ability to roll out the property to the beneficiary who then sells it and takes the exemption is great. But with family law in Ontario, as you'll probably be aware, the moment that that home is in the name of a spouse, it becomes a matrimonial home. So you're not protecting your child anymore by having these trusts in place unless you're prepared to pay the tax on the capital gain. So I'm hoping there might be some modifications to these rules, because also the ability to have a testamentary trust with a principal residence in the trust for a child under the age of 18. Well, who wants to distribute a home to a child of 18 years of age? I mean, I certainly wouldn't. So in any event, that's my little end note.
Principal residence rules used to be simple. They're getting more complex all the time, and we have to keep track of these various changes. So in your materials, Josh's part is the first tab, and then the second tab is our case study. And what I'd like to do, because this is the first time you've seen the facts that we're setting out, just quickly go through this with you so that you see the kind of cross-border situation we are envisaging that isn't that different from many that we see in our office. William and Kate have consulted with us in a manner to acquire a Florida vacation home that will cost $2 million US. William's concern is with creditors for their children and future grandchildren. But as we got discussing these matters with them, many more estate planning issues became evident. Kate and William have two grown unmarried children, George and Charlotte, both in their early 20s. Charlotte is an economist. George attended school in the U.S. and is about to get married to an American citizen and buy a home in a very high-tax state, California, but he's got a great job with Google. Is an American citizen by birth, so she is living in Canada as a resident, but she's a U.S. citizen here. She's been here for over 2 years. She heard something about the IRS coming after Americans living abroad, but she understood that their focus is on people who are tax cheats. She always filed, disclosing her various sources of income, employment, and of about $200,000. And so she simply wanted us to confirm that she shouldn't be about the IRS coming after her. She's not a cheat. Neither she nor her children have been filing U.S. tax returns, and remember, they're children born of a U.S. person. William, the Canadian resident husband, owns a business. He has 100% of the common shares of a beauty products manufacturing and sales business, which he estimates to be worth about $6 million. He'd like his daughter, Charlotte, to take over, but he's not ready to retire. He wants, in fact, to expand into the U.S. But he's not sure how to manage the transition from him in control to Charlotte eventually succeeding him. And at the same time, he wants to make sure that he and his wife have sufficient funds to live well and not use up all their money before they die. He also wants to provide Charlotte with proper incentives to remain in the family business. We discussed the possible estate freeze of a corporation, utilizing a discretionary family trust to enjoy the future growth in the value of the business and benefit future generations. Some of the other ancillary facts. Kate owns the family home, which is worth about $3 million here in Toronto. They bought it several years ago for only $1 million, so there's an accrued gain. Kate also bought a vacation home east of Toronto and bought it with $1 million of inherited funds. They each have tax-sheltered funds of $1 million, and they both hold unregistered funds of $2 million in their joint names. They put it that way because on the death of the first person, it would automatically, by operation of law, go to the second, and they wouldn't have to go through probate. An additional $2 million in cash was inherited by William. be used to buy the Florida property. Kate owns life insurance with a value of $10 million payable to her husband, and William's company has key man life insurance on him payable to the company. Now, Kate and William told us they realized they really have not paid a lot of attention to estate planning. They need to update their wills, their powers of attorney for property and personal care. Their wills right now are typical, very simple, mirror reciprocal wills, giving the entire estate of the one to the other, and back so on, of the survivor to children in trust until they're age 21. And like most couples, they have said to us, minimize taxes, and ensure the assets pass to the children's priority. They also would like to make some gifts in their will and maybe even during their lifetime. Well, they are universities attended by Kate and George, as well as a U.S. hospital that provided care to George for a serious health problem while he was attending school in the U.S. And so these are Canadian clients wanting to make gifts to American charities. So the whole fact situation is presented to us in this meeting. We try to understand what are the key points here. What are the issues? Where can we help? And where are there going to be some issues which we as Canadian lawyers are going to have to reach out to American counterparts to work cross-border and benefit the client from the expertise that comes from both Americans and Canadians. So that's the overall perspective. Lindsay's going to start diving right into it, and then we will be interjecting on the panel. And please, if you've got questions as we're going along, feel free to shoot a question to us. And we'll be here at the end anyway, so if you wanted to come up to us and ask us questions later, happy to do so as well. And we have a webinar that's going on, so there might be questions coming in from the ether as well. Lindsay, go ahead.
Thank you, Lauren. How do I advance this? I just use the computer here. Should be. Sorry, just have some technical issues here. One thing that I wanted to say as well before we get started is that we're all qualified to practice law in Ontario. We're not qualified as U.S. Attorneys. So whenever we plunge into these issues, we always engage U.S. counsel. And although we have a very good working knowledge of the rules, they change all the time, as we've just seen with our own principal residence trust rules, which was a complete shock. So whenever we are engaging in giving advice, we do utilize U.S. colleagues. And in some cases, the client already has an established connection with the U.S. attorney, but otherwise we have very good people that we work with. So that's a little bit of a caveat before we launch into this, because I'm going to be reviewing the U.S. estate tax rules as I understand them, but I am not a qualified U.S. attorney. So the estate tax generally, as everybody's well aware, on death in Canada, there's a deemed sale or realization of assets at fair market value, and this is really our estate tax. We also have probate fees. We're not focusing on those too much today, and probate fees are an administrative tax within the province where the person dies. But the tax on capital gain is the federal tax, and it can be significant. But the top rate in Canada is around 26% now. U.S. estate taxes, we'll see, can be much more significant. And U.S. estate tax is also imposed on death. And it's imposed, though, on the value of the worldwide estate, not just the gain. It applies to U.S. citizens, and it applies to U.S. domiciliaries. So that's basically people who are residing in the United States on a permanent basis. But what often catches Canadians is the the fact that there's a tax on what they call non-resident aliens. I've always loved that term. I just think of Martians or something. But on the value of the U.S. side as property. So in our fact situation, where we have, yeah, I just wasn't being aggressive enough with the pointer, where we have William wanting to buy this property in the U.S. At least he's come for advice before he's bought it. What we often find is people arrive and say, I just bought this great place in Florida. And you go, you've already bought it? Oh, yeah. You know, should I put it in a trust? And that's not such a great situation. So that's the first key. If people are thinking about doing it, they should talk to their advisors first. So U.S. citizens are subject to U.S. estate tax on their worldwide assets. And what's kind of key here is it includes life insurance. And a lot of people don't realize that, because in Canada, for the most part, a straight term life die-to-win policy is not subject to tax in most cases. But you know, essentially assume for a U.S. citizen it applies to everything that they might own, including property over which they have a power of appointment. And the top rate of tax for 2016 and going forward in 2017 is 40%. What's good is that the U.S. has a very generous exemption. So one of the key things to remember is that if the individual has assets that are likely going to be under this, you know, we'll call it $5.5 million, before, if they have assets under that value when they die, including their life insurance, then they probably aren't going to have a U.S. estate tax concern. And that does eliminate an awful lot of people. There's also a U.S. marital credit, which is equal to the regular exemption. So essentially at this point, there's about 10.9 million that can transfer between spouses before they're going to have any incidence of estate tax. There, we got it. So I included in your materials the rates that exist right now. And on the slide, it's kind of hard to see, but I have it at the back of the materials as well, printed sort of on a full page, so it's a little easier to read. But you can see that these rates, once you get over $1 million, become quite high at 40%. The exemption is indexed for inflation, and that's very useful. This exemption started out at $5 million, and as you can see, it's creeped up, and for 2017, it's going to be $5.49 million, so essentially $5.5 million exemption. There's also U.S. gift tax that's imposed on inter vivos gifts. So if someone tries to give their money away while they're living, they're not going to avoid these taxes. However, the lifetime gift tax exemption is also this $5.45 million, applying to U.S. citizens only, but it will, to the extent that it's claimed while someone's alive, it will operate to reduce the exemption that's available on death. So it's a unified credit which allows combined gifts during lifetime and on death of about $5.5 million before there's estate tax. There's also an annual gift tax exemption of $14,000 U.S. for U.S. and non-U.S. citizens, and that's a gift for anybody. So that can be a gift to children or nephews, nieces, parents, whatever. And there's a special exemption for gifts by a U.S. citizen to a non-U.S. citizen spouse of $147,000 U.S. annually, and this increases in 2017 to $149,000. There's no gift tax on transfers between two U.S. citizen spouses, and what's helpful is that these annual gift tax exemptions are in addition to the lifetime $5.45 million or $5.49 million that's coming in 2017. So you can see that utilizing these exemptions in a strategic way can really help for a U.S. citizen to divest themselves of assets that will be subject to potential estate tax on their death. And now we get to situations for Canadians who are not U.S. citizens and they reside outside the U.S., but they're still subject to tax on their U.S. side as property. And this will include, the most obvious one, real property, also includes stock in U.S. corporations, and personal articles in the U.S. So if there's an art collection down in Florida, or in this case California home, that could be subject to U.S. estate tax. There's certain allowable deductions both for citizens and non-citizens. For the non-citizen, it's a prorated deduction for debts, funeral, medical, and charitable donations, but it is quite restricted. And what's key in terms of the way the rules work is that it's typically only going to be an issue for Canadians who have a worldwide estate that's greater than the U.S. estate tax exemption. I'll explain that a little bit. So we have a treaty between Canada and the United States, which is a good thing because when I started to practice law, we did not. So there were situations where people would pay like 90% tax on a property on their death between Canada and the U.S. But we do have a treaty now that provides a great deal of relief. So generally the way that the treaty works, if the individual's worldwide assets are less than the U.S. exemption, which is right now about $5.5 million, then they generally do not have to worry about tax on their U.S. side as property. And in addition, the marital credit that is available to U.S. citizens is also recognized under the treaty. So essentially, as between spouses, if one spouse is transferring property to another spouse, they can have this sort of worldwide assets up to about $10.9 million before they're likely to have exposure to U.S. estate tax on their U.S. side as property. And the U.S. estate tax statute basically applies on U.S. side assets that are valued more than $60,000. So the threshold is very low, and that threshold hasn't come up in my career. But with the treaties, it alleviates a lot of the stress that would otherwise apply. And then there's a special rule that if the non-resident's worldwide estate is less than 1.2 million, and these are all U.S. dollars that I'm using just for simplicity, but that's also under their statute, of course, so using U.S. dollars. The estate tax applies only to U.S. citizens' property and to personal property that's part of a business in the United States. So it's just an alleviating provision. There is some accommodation for double tax under the treaty and our rules. So typically what happens is tax on capital gain on the property for Canadian tax purposes, and then U.S. estate tax is also payable. So there is a credit that can be applied on death. However, there's no relief for double taxation in respect of gift tax. So if U.S. gift tax applies because of a gift that, say, the U.S. citizen makes, and they've triggered a capital gain for tax purposes in Canada, there's no relief from that double tax. So a quick example of our scenario. We have William wanting to buy Florida condo worth $2 million. Say he's thinking, well, you know, I really should leave that to the kids because I've already got one who's going to be living in the United States, and gee, my daughter might end up doing that too. And that way, you know, I'm skipping a generation. It'll be a good idea. So what would happen in that case? Well, applying the rules as they exist, he's going to, by doing that, there'll be gross U.S. estate tax of $745,000 U.S. Now, the unified credit would apply, and because his assets are more than the $5.5 million, he gets only a fraction of the unified credit applying to his U.S. property. So the number that I've got there, unified credit is the greater of the $13,000 is to exempt the first $60,000. Well, obviously, we're going to want to take option 2. And option 2 is the value of the current credit, maximum credit, on $5.5 million, times the value of his U.S. assets, $2 million, over the value of his worldwide estate. And so he gets a tax unified credit of $425,000, but he still has net U.S. estate tax owing of $320,000 U.S. So this is not good. And Lauren's going to tell us what William should do to be smart in how he holds the property.
U.S. vacation properties and the way we hold them have gone through a number of iterations over the years. A number of years ago, it was typical to set up, let's say, an Ontario Business Corporation that would be a single-purpose company to hold U.S. property, and the Canada Revenue Agency would understand, well, that's really to minimize U.S. estate tax. It's not really a business corporation, so we'll ignore and close our eyes to it. But several years ago, the same Canada-U.S. tax treaty that Lindsay referred to was amended, and this relief was provided. And so since 2007, the CRA has said, if you use a single-purpose Canadian company, we're going to impose a taxable benefit on the shareholder for using a corporate asset without fair value being paid for it. So we do not use Canadian corporations anymore. Instead, we try to use other arrangements that will meet a couple of criteria. One is obviously we want to shelter the estate from U.S. estate tax, but also we have to think about sale. And on a disposition, we would like to minimize both U.S. tax and Canadian tax. And frankly, a corporation is not a good way of minimizing U.S. tax, because U.S. corporations don't have the same long-term capital gains rate of 20% that individuals do. They have regular corporate tax of at least 35%. What we're using much more today are family trusts, domestic Canadian family trusts. Typically, let's say one spouse with the resources, the settlor, will transfer the assets into the hands of the trustee, let's say the other spouse, to hold legal title to the California property for the benefit of the family, except not the spouse transferor. That we can't have that spouse either be a trustee or a beneficiary, or under U.S. estate tax rules, the property will be retained within the transferor spouse's estate at death. So what we try to do is give some protection by way of a lease arrangement and create successor trustees within the trust as well. And under that arrangement, if there is a sale, then we don't have a corporation that is disposing of it, but we have a trust which can be taxed as an individual, or if the gains are allocated through to the individual residents of Canada, the long-term capital gains rates will apply as well. So in those scenarios, or in that scenario using a family trust, we can accomplish both of our goals of shielding the estate from U.S. estate tax and minimizing capital gains tax on death. One final element to it, because it's a Canadian family trust, after 21 years there's going to be a deemed disposition. So we wanted to think ahead, and we worked with U.S. counsel on being able to roll out a U.S. real property interest from this trust to Canadian resident beneficiaries without triggering tax either in Canada, because it's a roll over under subsection 107.2, or under the U.S. rollout rules as well. It can work. So that's our classic arrangement. We've got a bit of a problem here, though, because Kate is an American citizen. If she is the trustee in control, are we just jumping into the fire by giving her control and keeping the property within her estate? Now, if we plan, as Lindsay has said, maybe it's possible to reduce the worldwide estate of U.S. citizens in various ways to bring them down below the threshold of $5.5 million, then it's not a problem for her to be the trustee. And so we want to think about that as we're going through. Lindsay?
Okay. So thank you, Lauren. we find we are doing a lot of these Canadian domestic trusts to hold the U.S. property, and it's always an interesting conversation because if, in the example, if William, Dad's putting in all the money and he cannot be a trustee or a beneficiary, so he goes, oh great, like everything, I pay and I get no benefit. But it's always there's got to be a very high level of trust when these things are put together, because the control essentially is in the hands of the person who's not putting the money in. So some general strategies for holding U.S. property. One of the first ones is very often people will, when they've already bought it, they'll say, oh yeah, we picked out, we did it in joint tenancy, so if one of us dies, it'll be really an easy situation on death. We won't have to probate a will. That's not a good idea, because in the United States, for the purposes of the U.S. estate tax, there's a presumption that joint property is wholly owned by the first person to die. So when the individual dies, it's not half the value that's considered their U.S. taxable estate. It's the whole value, and it is a rebuttable presumption, but it's obviously a problem. So, in a simple situation where they don't want trust, they don't want anything fancy, at least make sure that it's tenants in common, not joint tenancy. If both spouses are non-U.S. citizens, then the strategy is to make sure that the spouse with the smaller worldwide estate owns the U.S. side as property. So if, typically there's one spouse who's got a lot of inherited assets and the other spouse, just has their RSP or whatever, then the U.S. side as property should be purchased in the name of the spouse who has the smaller worldwide estate, so that the way the formula works under the treaty, the tax on the death of the owner will probably be not subject to U.S. estate tax because it'll come under the threshold. As Lawrence discussed, utilize a trust to purchase U.S. side as property. And in other situations, if you have a U.S. citizen spouse, as we do here, it may be advisable to simply have the U.S. citizen spouse own the U.S. side as property, because they may be subject to U.S. estate tax in any event, or if you planned it properly, they hopefully will be under the threshold. But rather than have a situation where the U.S. citizen spouse is going to be subject to estate tax, and then the properties in the non-citizen spouse's name also creating a challenge to avoid the U.S. estate tax, this is often a simple approach. Then if you've set this up so that you have the U.S. side as property in the name of one spouse, what's important is that there will, not just say give everything to the surviving spouse, which is what's happened with William and Kate. They have wills that are classically done when the first baby is born, and young couples come in, they have not much, and they do these simple wills, and then they forget about it for 30 years. So in those situations, all the planning that's been done can be undone because all the assets flow to the survivor, who then has to start planning all over again. So the advice is always to have the U.S. side as property if it's in the name of one spouse or the other, be subject to a spousal trust under the owner's will, so it doesn't form part of the survivor's U.S. taxable estate. There's also a vehicle called a qualified domestic trust, or at least this is the acronym is QDOT. The Americans love acronyms, and I find it really hard to keep up with them sometimes when they're talking about all these different vehicles. But in any event, a QDOT is a type of trust that can be set up either under the individual's will, or actually the survivor can set it up under the U.S. laws. And the idea is that if the estate that's going to be subject to tax is more than the $5.5 million, the excess can be put into a QDOT and the tax deferred until the death of the second spouse. Now, this is not a saving, it's a deferral, and if the QDOT disposes of the property or any part of it, or distributes any part of it to the beneficiary spouse, then tax is payable at that time. However, it can be quite a useful vehicle to use. And the trouble is that a QDOT has some very strict requirements, as you can imagine, because the United States wants to make sure that at the end of the day, when the second spouse dies, that they get their pound of flesh, so to speak, and they get the tax. So the QDOT requirements are include that there must be one U.S. resident trustee, and that it be governed by the law of a U.S. state. So it's not an ideal situation, but it does allow some relief for very high net worth individuals. So let's just look at the case study in a little more detail. And I summarized it just in the overheads in a list because I find it sometimes conceptually easier to look at it this way. So Kate has some significant assets, but as we'll see, it's this life insurance policy that's really going to cause grief in the event of death and under their current planning, which is, as I've said, no planning, basically. So she has her $3 million Toronto home in her name, $1 million cottage, $2 million in securities and cash, which is joint with William, and $1 million RSP, and then this very large life insurance policy that she was talked into. So William's assets are the family business. He's got the $2 million to acquire the Florida home. He's got the securities, again, in joint name with Kate. He also has a $1 million RSP, and he's got a corporate-owned life insurance policy. So I wanted to just do an illustration of what's going to happen if they do nothing. So suppose William dies first and he leaves all his assets to Kate. She will inherit from William an additional $10 million in assets. So when Kate subsequently dies, her U.S. taxable estate will be approximately $26 million. That's including her life insurance policy, assuming there's no change in asset values between William's death and her death. So the U.S. estate tax exemption shelters in 2016 $5.45 million, and her U.S. estate tax will be approximately $10 million, less a tax credit of approximately $2 million. So it's going to be $8 million in tax payable if they don't do something to clean up their planning.
Ouch.
So, and then what if Kate dies first, leaving all her assets to William? Well, first of all, in calculating Kate's U.S. taxable estate, that jointly held securities account is going to be considered 100% owned by Kate. So that's adding another $1 million to her taxable estate. The proceeds of insurance form part of her taxable estate as well. So her estate could be considered to be $17 million U.S. if she dies, and assume that she leaves it to William. So the unified tax credit and marital exemption should shelter $10.9 million from tax, but there's still going to be about $2.5 million in tax payable by Kate's estate. And you could imagine their surprise when they come in to see you, because spouses are generally comfortable with the notion that there's no tax when one spouse dies, leaving everything to the other. And that's essentially true in Canada. But in this particular situation, with the way the numbers work, that's not going to be the case for William and Kate. The other problem is that capital gain realized on principal residence is not exempt from tax in the U.S. So right now there's about $2 million accrued in capital gain in our fact situation on the Toronto home. So that's obviously an issue for them right now, because if they sell it, it's exempt in Canada, but it's not exempt in the U.S. So Kate, who's going to get compliant and start filing her U.S. tax returns, will have a taxable event on the sale of that principal residence. Again, there's some double tax relief under our Canada-U.S. tax treaty, but the relevant province or territory where the individual lives may not provide any relief. So obviously, there's got to be better planning, and Kate should take steps to reduce her taxable U.S. estate value. So one of the things we often tell spouses in this situation is, you know, if you put assets like the securities portfolio, maybe it was all of William's and he put it in joint name because he wanted to avoid probate fees. So if those assets are, essentially owned by William and she's holding on a bare trust for him, it's possible for William to reconvey to himself the assets that he put in joint name that are really his own. The Toronto house, we would suggest that she gift to William, utilizing part of her lifetime U.S. gift tax exemption. So you'll recall that she can, for a U.S. citizen, has a $5.5 million gift tax exemption, and although it will reduce her estate tax exemption on death, because we know the Toronto property is probably going to keep going up in value, it would be a really good idea to gift that property now, well, it's only worth $3 million, and not let it sit there for another 10 years in her name. And that will also assist in terms of the fact that there's a disconnect between tax on capital gain on principal residences in Canada, which is tax exempt, and in the U.S. when it's not. And then we also might suggest they consider starting to make annual gifts to the children. So Kate can divest herself of $14,000 annually to each child, $28,000, and that way maybe reduce some of her assets. And then Kate's life insurance, and this is a big one. Kate should be holding her life insurance in an irrevocable life insurance trust. And again, we have an acronym for that, as the U.S. attorneys do, called an ILIT. And she may be able to assign her existing policy, assuming it hasn't got any significant value, but just a term life policy. But even if she does, she has to live 3 years, or the value of it will be clawed back into her U.S. taxable estate. But I think it's key to remember, if a U.S. citizen is ever acquiring a life insurance policy, they should acquire it through one of these ILITs. And again, it's expensive. We do not draft these. We have U.S. attorneys draft them. And so the client sort of looks horrified when we say that they're not only going to pay our fees, but they're going to pay U.S. attorneys as well. But you can see in the long run, it's going to save an awful lot in U.S. estate tax exposure. And then I talked about the QDOT. And so we would suggest to Kate consider establishing a QDOT in her will. And how that would work, her will would say, leave everything to William up into my maximum unified tax credit for U.S. estate tax purposes at the time of my death. And anything over that pours into a QDOT that does not have to be set up until after death. And then they have the option to either set up the QDOT and defer the tax on the excess over the exemption limits, or they can just bite the bullet and pay the tax. So depending on the amount of excess, this QDOT structure may or may not be useful and may or may not be used. But the idea is we don't know what the situation will be. The exemption will continue to go up. If Kate and William live long enough, that their assets may decline in value as they enjoy life and spend. But the idea is to try and defer the tax if there's going to be tax beyond the exemption level. William's will. So William should not leave everything to Kate, as we've seen, because that just piles more assets into her name and is a gift to the U.S. government when she dies. So William's will should provide qualifying spousal trusts for Kate. And there's special language they call, again, acronym HELM language, which basically is so simple, and it's almost stupid, because if you say, hold the residue of my estate for the benefit of my wife, pay her all the income, and encroach on capital as needed for her benefit, that will possibly be interpreted by the U.S. taxing authority as allowing her some sort of ownership interest. But if you say that you can encroach on capital for her health, education, and in order to maintain her lifestyle, then that magic language satisfies the U.S. taxing authority that she does not actually own the capital. If Kate acquires the Florida property, rather than through the trust, as Lauren suggested, she should establish a Canadian resident spousal trust in her will for the Florida property to exclude it from Williams' U.S. situs assets. And both spouses should consider leaving assets for their children and their issue to U.S. grantor trust. And I'm going to get into that in a little bit more detail later. But right now, I want to turn it back over to Lauren, because one of the things that Kate and William have indicated is that they're interested in doing an estate freeze with respect to the company.
And I'll just flip along here to a, oops. Now,
We're just having technical problems.
While we're just fixing this up, what I'm going to focus on is Williams' business and the fact that it's worth $6 million. I want to go to my slide here. And as I mentioned in reading the case study, William would like to plan for succession for his daughter to take over. They want to minimize the capital gains tax that would be payable in respect of William's 100% ownership of the shares of the Canadian business. So how would we combine that with the existing assets that are there? Okay, we're still working on the technical part. In your materials, I've got just after Lindsay's materials, you'll see a diagram called estate freeze ownership structure. That's what's going to be on the screen shortly. The idea here is to utilize these famous family trusts that we've been talking about in various contexts. They're so flexible. They give us asset protection, tax deferral, the ability to defer gains to the next generation. We want to use the trust in this context. And the way classically we might do it is through this kind of corporate structure. The operating company at the bottom is the beauty manufacturing company, and I'm recommending setting up a holding company. And the way we would do the freeze to fix the value of Williams' interest and put a cap on the maximum capital gain that would be realized on sale or death is for William to take his shares of the beauty company that are worth $6 million, common shares, transfer them under Section 85 to the holding company on a share-for-share exchange basis, and take back from the holding company, I'm calling it them Class A super voting preference shares. They have a redemption amount, either redeemable by the company or retractable by the individual for the $6 million, and they contain voting rights that will always give William control over the holding company during his lifetime, but on his death will cease to vote. The shares will be automatically converted into Class B shares, still worth the same redemption amount, but non-voting. So we have a share-for-share exchange as the first step to fix the value of Williams' interest. Now, because all of the $6 million of the group has been taken up by the preferred shares in the holding company, we can have another shareholder, even a related party, such as a family trust, come in with nominal value to subscribe for new common shares. If we haven't done a proper valuation, that's a risk. If the company's really worth $10 million, and we've only taken back $6 million in preference shares, we could be creating a transfer, a gift, trigger a capital gain, or even a taxable benefit of the difference. So it's really important to get a proper valuation here of what the company is actually worth. In this example, it's worth $6 million, so the holding company preference share redemption amount is $6 million. The family trust, a settlor, and that can often be a grandparent, a friend, a relative, but not William or Kate, would make a gift of a nominal amount, let's say $100, to trustees. And here we'll talk about who the trustees will be in a moment, but they have legal ownership only of the assets. The cash coming in is going to be used to subscribe for 100 common shares in the holding company. Those are the assets to begin with. And the trustees hold legal title not for themselves but for the beneficiaries, and they will be the members of the family. We'll talk about the kinds of permutations and combinations that have to be worked out in these situations. Very often we'll have the husband and wife as two of the trustees, and I recommend what I call a friendly stranger as a third trustee, so that we've got a majority of three, and that third person could be the lawyer, the accountant, a business colleague, somebody that the family is comfortable with who will know a little bit about what the family is doing. And the decisions are very minimal because this is a capital gains play that will look out into the future if there's any disposition. We're not talking about current income and every year having to file a trust tax return, so there shouldn't be an issue there. And so we have our three trustees. Now let's look at the beneficiaries. We've got in our fact scenario two children, one of whom is living in the States and about to marry. The other is a resident of Canada. In a recent estate plan that Lindsay and I did, we had two trusts set up. One trust was a classic situation for the resident child, same trustees, and conventional Canadian trust. There, we got the picture up. Thank you. For the U.S. child, what we did was, again, as Lindsay said, working with U.S. counsel, we set up a U.S. grantor trust that would have the same entitlement to common shares as the other trust for the Canadian resident child. Again, nominal capital going in, but the key to doing this from a U.S. point of view and not offending any Canadian rules was, in this case, it would be William, the Canadian resident father, the grantor, creating a trust for the boy who's gone to the U.S. and having the right to revoke right in the terms of the trust itself. And therefore, from a U.S. point of view, if there is any liability for tax that arises from a disposition or income within the trust, the liability will not lie with the U.S. child, but technically it applies back to William in Canada. But he's not a U.S. citizen, he's not a U.S. resident, so we have shielded any compliance requirements and any liability from U.S. tax by using that U.S. grantor trust. One other solution we've used over the years where there's a single omnibus trust for children, and this was 4 children, one of whom was going to be living in the States, but the other 3 were going to remain back in Canada, and the parents wanted equal treatment. But we didn't want to have that one U.S. child faced with compliance and serious tax problems. So again, working with U.S. Tax Counsel, we drafted a typical Canadian trust, but it said in respect of any beneficiary who is a U.S. person, that would be somebody who is a resident of the U.S. or a U.S. citizen, while that person is subject to U.S. tax, that person cannot be entitled to any income or capital distribution from the trust during its term. However, at dissolution of the trust, we can bring that child back in and share in the same way as the Canadian resident children, and that doesn't offend the U.S. tax rules and doesn't completely exclude the U.S. child from what the parents want in terms of participating with the other children. So those are 2 different variations on a theme, but the basic idea is that we are creating this family trust to get the future deferral, but we have to take into account, if there's a U.S. child, what's the best solution to minimize friction across the border. So the other element to this that I wanted to throw in, we have life insurance that is currently owned by the beauty company on Williams Life, Keyman Life Insurance. And there's a single company that's an operating company subject to creditor risk. So if there are lawsuits and creditors come to seize assets, they could seize that life insurance. Instead, by putting a holding company into place, let's have the life insurance be held by the holding company. We can have the holding company pay the premiums. It's going to be the same after-tax cost, whether it's in the operating company or the holding company, but by putting it upstairs, we insulate it from creditor risk downstairs. So that's something that's a very important part of all the estate planning, is asset protection, not just the tax planning. That's how we would create the estate freeze. Lindsay?
Thank you, Lauren. So as we're going through the planning with William and Kate, we've got some good suggestions as to what they should do in terms of one spouse has died and what the will of the first to die should say. But then if both spouses have died and their wishes, like most parents, they want to treat each child equally and distribute to their children on their death. But they also want to make charitable gifts. So in this case, we're suggesting in both Kate and William's wills that they set up some sort of testamentary spousal trust. And yet, on the death of the survivor, they would like to make some charitable gifts before the residue goes to their children. Historically, we've been quite restricted in terms of structuring charitable gifts on the death of a surviving spouse where there's an intervening spousal trust. And I'd like Pam to maybe address the new rules, which are going to allow us a lot more flexibility.
So I don't know how much more often we can keep calling them new rules since we've known about them for some time now. But in terms of the actual donation of the gift, there are several ways to donate to a registered Canadian charity or to other qualified donees. Can anyone hear me? Okay. So the first is to make a donation now while they are still living. Another way is to make a testamentary gift, such as making a bequest or a legacy gift through your will. So the donor will state in his or her will that on their death, the property will be given to the qualified donee by the executors. The donor can make a gift of cash or of property, including shares of a corporation or of artwork. A donor can also name a qualified donee as the beneficiary of a life insurance policy or designate the proceeds of a registered plan, such as RSPs, RIFs, TFSAs, to the charity. And a donation can also be made by way of trust, where the donor establishes a trust, and upon the death of the donor or on the death of the surviving spouse, the balance of the trust is paid to the charity. Now, with respect to the testamentary charitable gift regime for 2016 and for subsequent taxation years, I'll provide a brief summary of what the rules are. So, as Lindsay had mentioned, there's a lot more flexibility in claiming the donation tax credits if the gift meets all of the following requirements. First, the gift must be made by the deceased's graduated rate estate or a GRE. The gift must be transferred to a qualified donee within the first 36 months after the individual's death. But there has been a legislative proposal to amend this time frame, so I'll come back to this. And the property must have been received by the estate on and as a consequence of the individual's death or have been substituted for such property. So if the estate is a graduated rate estate, a GRE, at the time the property is transferred to the qualified donee, then the donation tax credit can be claimed in the estate in the taxation year in which the donation is made, the estate in an earlier taxation year, by the estate in any of the following 5 years, subsequent taxation years, and it can also be claimed by the deceased in the year of death or by the deceased in the year prior to the year of death. If the estate isn't a GRE at the time the donation is made, then the estate may only claim the donation tax credit in the year in which the gift was made or in any of the subsequent 5 years. Given that an estate can only be a GRE for about 36 months, this is a tight timeline for estates that may take more than 36 months to fully administer. before the gifted property can be transferred to the qualified donee. However, as I'd mentioned earlier, draft legislation was released in January 2016 that proposed to extend the 36-month period to 60 months after the death of the individual. So this will give the executors a little more breathing room, as donations made by an estate within the 60 months following death of the individual can be carried back to the individual's last 2 returns even after it ceases to be a GRE. Now, with respect to charitable gifts by a life interest trust, such as an alter ego trust or a joint partner trust, if a life interest trust makes a donation within 90 days after the end of the calendar year in which the life interest beneficiary dies, the trust can allocate the donation tax credit to the short taxation year of the trust that resulted from the beneficiary's death, or in the year in which the gift is made, or again in the subsequent 5 years. So bringing this back to our case study, if Kate is the beneficiary of a spousal trust and she passes away on June 12, 2017, I know that's a very soon date, and the spousal trust makes a donation to the hospital or to the American University before March 31st, 2018, then the spousal trust will be treated as having a year end of June 12, 2017, and the donation tax credit can be allocated to the year in which Kate died.
Thank you, Pam. I'm very relieved at these rules, which allow the donation to be made by March 30th in the year following the year of death, because particularly in alter ego trusts, and I had one where the remainder did go to charity, and I had all the special language with discretion for the trustee to make the gift. But I was so concerned that my dear old lady, who was the beneficiary of this alter ego trust, was going to die on December 31st, and we wouldn't be able to make the donation in time. So these rules allow a great deal of relief, and pleased about these rules. Not so pleased about the principal residence trust rules. So in this situation, though, Kate and William want to make donations to American charities. And this is a very common issue that comes up. And Jim's just going to address what tax relief in Canada might be available for making gifts to American beneficiaries, charitable beneficiaries.
The starting point is absent the U.S. treaty.
Sorry, am I on the air now?
Yeah.
Yeah, okay, sorry. So the starting point is for relief for a Canadian taxpayer making a donation, you need a qualified donee. So that's the typical charities around town that we all hear about. When you give to a foreign charity, such as here, a U.S. university or a hospital, it's not quite that simple. A university might be a qualified donee under our domestic rules. There's a schedule to the Tax Act that lists a whole bunch of universities. If they've applied and been recognized, then they're just on the list, the same as a Canadian charity. So that they're qualified donees, you can make a donation to them. CRA maintains a list on its website of all qualified donees. You can look them up, find out whether the guy who knocks on your door is legit, whether a U.S. university is on the list. Assuming here that the university in question is not one that's on the list, then we have to look at the tax treaty. The tax treaty has two different situations in which Canadians can make deductible donations. One is if the U.S. university is a 501c3 organization that's exempt in the U.S., and undoubtedly this one would be, then a donation to it is recognized not because it's a qualified donee, and I'll come back to that, but because under the treaty it's as if it were, and that's a significant distinction. It gets a little better here because the university we're talking about was attended by Kate and George. So the treaty has a more specific rule that says for a donation to a university that was attended by the donor or a family member, then that's a subcategory. The distinction is for the first type of charity that I mentioned, you can only get a deduction in Canada, or credit in Canada, to the extent you have U.S. source income. So if you have no U.S. source income and make a donation to a U.S. charity, you don't get any relief. The distinction for the university that was at which the donor or a family member was enrolled, you don't have to graduate, you just have to have been there. That limitation based on U.S. source income doesn't apply. So that's the good news. If you go to that university, it's on this little subset of organizations to which you can make a donation even without U.S. source income. The limit in Canada is 75% of income for the year, so you can't ever shelter all your income down to zero, except in the year of death or the previous years. As Pamela said, when you make gifts by will, the new rules give you some options. The good news is in the year of death or the previous year, if the election is made, you could shelter 100% of your income. If you make the donation to the Canadian or to the U.S. university and it's not one that was attended, then you have that 75% rule. And again, you have to have U.S. source income. Same rules apply to the hospital, except we don't have a schedule of U.S. hospitals, so it's going to have to stand or fall on the basis of being a U.S. exempt organization. And again, you'll have to have U.S. source income to be able to claim the deduction. I've seen situations where hospitals sometimes are affiliated with universities, and if the university happens to be one that is on the schedule and it's a qualified donee, then for significant gifts, I've seen people make the donation to the U.S. university on the understanding that they would have some sort of arrangement with that hospital, such as for research or that sort of thing. So indirectly, the Canadian donor can assist the U.S. hospital by using the U.S. university that is itself a qualified donee as an intermediary. So in this case, I think William and Kate are probably okay because they've chosen the university that Kate was enrolled at and George was enrolled at, and the hospital presumably is exempt under the U.S. rules and would qualify with the caveat that they have to have U.S. source income.
Thank you, Jim. So the final piece of the puzzle for Kate and William is how they're going to structure the gift on the death of the surviving spouse to the children. And because both children, well, one is already pretty much committed to a future in the United States, because they're both born to a U.S. citizen, there is this assumption that they are also U.S. citizens. So they're going to have to deal with their U.S. citizenship and look at how that's going to impact in the future when they inherit from their parents and when they acquire their own wealth. For William, we would certainly recommend that whatever, not for William, sorry, for George, we would recommend that whatever William and Kate leave to George and his children in their will be set up so that it goes to a U.S. grantor trust, sometimes called a pour-over trust. And the model that is followed by our U.S. estate planning colleagues, where there's wealth that's going to perhaps at some point attract U.S. estate tax, the beneficial entitlement under will is almost never left directly to the child or grandchild. It is left to one of these special U.S. grantor trusts. So these trusts, again, would be drafted by U.S. experts, specialists in estate planning, and clients aren't too happy when we tell them that this is the model of perfection that they should follow. because it means involving their child in the planning, and their child has to then secure counsel and have one of these trusts established. And then in this case, it would be George's U.S. grantor trust would be the beneficiary of the half of the residue that William and Kate want to leave to George and his issue. And these trusts are interesting, and basically the idea is that on George's death, what he's inherited from his parents and that's gone into this grantor trust will not be subject to U.S. estate tax. And the concept of these trusts is that you would only withdraw what you're going to consume. So if George were to inherit, say, $5 million in this trust, he would only withdraw from it what he was going to spend on trips or whatever. And he could, with this trust, buy properties. If he wanted to buy a Colorado ski chalet or something, he would buy it within his U.S. grantor trust. And the idea being to shelter the exposure to U.S. estate tax when George dies. So, people's eyes do glaze over when you talk about, when your 5-year-old child passes away. You need to be concerned about this, but it is a concern. And for Charlotte, because she's got this U.S. citizenship issue, having been born to a U.S. citizen, she may decide at some point that she wants to renounce U.S. citizenship, and my understanding is if she wants to, she should do it soon. And they often are quite lenient about it when someone who's just turned 18 goes and says, I'm a U.S. citizen, but I've lived in Canada my whole life, and my connections are all with Canada. But if she also ends up in the United States, which is possible, then again, a U.S. grantor trust would be the model, rather than the type of classic trust that we set up under wills, which would be a testamentary trust. And in Canada, we used to always push these testamentary trusts because of the graduated rates that were applicable to trusts set up under wills, and now we've essentially lost that advantage. So in a way, it gives us more flexibility in terms of what we do with the planning for children in the next generation. So essentially, I think that's our
I want to add one thing. Early on, we've talked about various assets, and artwork is often an element. Lindsay mentioned that U.S. situs property includes not just real estate, U.S. stocks, but also personal items such as artwork. Possible solution here is a trust. Setting up a Canadian family trust that has several functions. It could be part of the estate freeze, but it also would function as the vehicle to acquire artwork, because now neither Kate nor William is the owner, so they don't have U.S. situs property. They can move the art from Toronto to California back and forth because it's under the umbrella of this Canadian owner, the Canadian trust. It's still subject to all the Canadian tax rules, such as the 21-year disposition we have to be concerned about, but it does give us some shelter against U.S. estate tax in respect of potentially valuable assets. So we have now come to the end of our presentation. We're open for any questions that people have, either live or afterwards. We'll stay here for a while as well. No questions? Okay, well, thank you very much for your attention, and we look forward to seeing you in the new year.